Sources of law. There are two main sources of law, namely formal and material. Law that is created by the will of the state or through command of the sovereign is known as formal source. Material source means that source which has some matter, material or data available. Material source can be of two types, namely legal and historical. Historical source includes religious texts, opinions of ancient writers, etc. Historical source is a major source of our personal laws pertaining to marriage, divorce, succession, etc. Legal source has five main subcategories which are as follows. First, legislation. Legislation means declaration of legal rules by a competent authority that confers upon such rules the force of law. The competent authority is known as legislature and the persons involved in making laws are known as legislators. Laws that have their origin in legislation are known as statutes or enacted laws. Example, the Indian Contract Act of 1872. Second, precedent. Precedent means a court's decision that is considered as authority for deciding subsequent cases involving similar facts or similar legal issues. Third, custom. Customs are widely accepted ways of doing something in a continuous manner that have been existing as a practice since a long time. Law based on custom is known as customary law. Fourth, agreements. Agreement between two parties creates mutual obligations. And when such agreements are legally enforceable, they are perceived as a source of law. Agreements can be of various types, such as assignments, contracts, grants, or releases. Fifth, professional opinion. Professional opinion means the opinion of eminent jurists and law scholars. Such opinions are referred for seeking clarity on any legal query. Thank you friends for watching this video. Do subscribe this channel to learn more about law.